Welcome to week 4 of evidence. We will continue our discussion of privileges and discuss the cases from your casebook on pages 593 to 615. The first case is Prink v. Rockefeller Center. This is a Court of Appeals case of New York from 1979. As background, we have a plaintiff's decedent who was killed from a fall in an office building. The plaintiff brought a wrongful death action against the owners and architects of the building, alleging their negligence in the installation of a desk and maintenance of a window that caused the decedent's fall. The defendants contended that the death was actually a suicide. The issue is whether the plaintiff's conversations with her husband's psychiatrist after his death were privileged. This court held that the conversations were not privileged. If the decedent had survived and still brought the suit, he wouldn't have been permitted to claim the conversation was privileged because the suit itself put his mental condition at issue, meaning the privilege would have been waived even if he had lived. The next case is Jaffe v. Redmond. This is a Supreme Court case from 1996. As background, we have a defendant who was a police officer who had shot and killed a man named Ricky Allen. After the shooting, the police officer received counseling from a licensed social worker. Allen's survivors then brought a civil rights claim and wrongful death claim to recover damages. The district judge ordered the social worker to turn over her notes from that meeting. The defendant and the social worker both refused. The judge then told the jury they could assume what would have been in the notes would have been unfavorable to the defendant. The Court of Appeals reversed, holding that the therapist-patient privilege was applied here and was subject to a balancing test. At issue now was, did a therapist-patient privilege exist between the defendant and the social worker, and did that prevent their conversations from being disclosed? The Supreme Court held that confidential communications between a licensed therapist and her patient in the course of diagnosis and treatment are protected from compelled disclosure. It also held that the privilege extended to licensed social workers who were administering psychotherapy. The court rejected the balancing test analysis of the Court of Appeals, but did say that exceptions would apply to this privilege. The next case is People v. Sergio. This is a Supreme Court Kings County of New York case from 2008. As background, we have a defendant who was accused of murder by killing her newborn baby by exposure. She claimed a doctor-patient privilege to a statement she had made to an EMT saying that she had not been pregnant, which the prosecution felt showed her guilt, and to her hospital records. The prosecution claimed that the defendant waived the privilege by having her mother present, so breaking that confidentiality, and because there was a state law that mandated disclosure of child abuse or potential danger to another person. At issue was whether the defendant's statements and hospital records would fall under the doctor-patient privilege, even though the statement was not made to a physician. For holding as to the defendant's statements to the EMT, the court noted authority going both ways, but said that more jurisdictions say the privilege does apply because an EMT is an agent of the hospital where the patient was being transported. Next, the court discussed the law requiring disclosure to protect a child or another person. The court held that the EMT and hospital were obligated to do what they could to ensure a person, the newborn in this case, was not in danger. But they did not really grapple with the question of, does this mean the disclosure is discoverable by the prosecution to use at trial? Our last case is Trammell v. United States. This is another Supreme Court case from 1980. As background, the defendant was convicted of importing heroin. At trial, the defendant's wife, also an accomplice, was permitted to testify against her husband regarding her role and her husband's role in the heroin distribution conspiracy. She cooperated with the government to receive leniency. At issue was whether a spouse can give adverse testimony or testify against the other spouse over their objections. The Supreme Court held that yes, a spouse can choose to testify against their spouse, even if that spouse objects, as to non-confidential communications and acts. This ruling modified a previous adverse spousal testimony rule that the federal courts had, which gave spouses the right to exclude adverse testimony from their other spouse because it would promote marital harmony. The court here in Trammell didn't find this marital harmony argument compelling any longer, saying that if a spouse was willing to testify as to adverse issues with their spouse, that there was probably not a lot of marital harmony to begin with.